All right, so the agenda for this lecture. First, I'm going to go over a quick confidentiality disclaimer. Then, as I go through my videos where I will be talking about case examples, my plan is to give 3 layers if I can, if not 2. Cases are valued differently. There are different types of violations, different types of claims, different plaintiffs, different injuries, different outcomes. So no case is alike, but we try to separate cases into 3 levels, gold, silver, and bronze, with gold cases being the highest value, the most impactful. Usually they're the highest value cases in terms of damages and fees, but sometimes it's just the case itself is so impactful, or a class case or some other reasons. But again, it's a helpful way to analyze these cases in terms of potential outcomes, strengths, weaknesses of these types of cases. But really, even in stratifying and kind of giving tiers, you can see that there are incredible client outcomes even on bronze cases. So that's the plan. Let's get started. All right, so first, the confidentiality disclaimer. Most cases that get filed under these laws get settled. The vast majority, 99% or more. Very few cases go to trial. Most settle, or sometimes they lose for some reason, but the vast majority of these cases settle. With that said, when cases are settled, there's often a confidentiality agreement. And what that says is that the terms of the agreement, money, offers, counteroffers, and sometimes even facts of the case in some restricted ways are meant to be confidential. And plaintiffs, consumers cannot go on Facebook and brag about it and do certain things. That means I have to be careful, and our team has to be careful. So when we describe case examples, we have to strive to not describe just one specific case. So some of these are kind of amalgams of different cases. We've changed a little bit of the facts to make sure that we are not violating any agreements. But to the extent that they do resemble cases, a lot of these cases are similar, and been doing this for so long that defendants engage in repetitive conduct. But to the extent that any resemblance does happen, it was certainly unintentional, and anything that may remain in here as a fact is certainly something that's publicly available. All right, so we're going to talk about case study number 1 for the incredible FDCPA case examples. This is a bronze case. We call those, our lower level value cases. Sometimes we say they're the blocking and tackling cases, or even they keep the lights on. Usually there's higher volume of the more technical lower cases, but you can help more people. In this case, we sent, Swift Law North, when we get consumers into our litigation program, we filter them through certain questions and try to decide what route is best for them to take, whether it's litigation right away, disputing, maybe they're not suited for litigation, they go back to our credit repair affiliate partner. But usually what we do is we identify third-party accounts and we send them all letters, via fax or some other way, email. We try to collect information. Now remember, go back to one of our videos. This is not, in fact, you have to go ahead to a video on the FCRA. This is not a validation and verification request letter. Unless that letter is sent within the first 30 days, it means nothing. This letter is different. It's built upon the principles of new Reg F requirements and the FDCPA in general. So anyway, we send that letter out. What it does, it tells the third-party debt collector, the 3PC here in shorthand, you can only contact our client in certain ways, and we don't know what this is, we dispute it. And what that does, it triggers responsibilities under the FDCPA. On one hand, the debt collector has to listen within reason to the consumer's wishes about where, when, and how he or she can be contacted. These new regulations allow that. If it's not a good time to be called by a debt collector during business hours, you can tell them that, for fear of losing a job. If it's not good to be called between 5 and 8 p.m. because that's family dinner time and putting the kids to bed, you're allowed to tell a debt collector that. And often they don't listen. And another thing what we do is, if there's a legitimate and bona fide dispute about this debt, we need the world to know. And the FDCPA requires, as you've likely learned through our video series, that if a consumer disputes a debt, that has to be reported as such. The remarks, the dispute codes, the condition codes, and credit reporting have to have the debt as disputed. And here, the debt collector failed in 2 ways. On one hand, it violated the requests in the letter that we sent out, and it did not, this debt collector, communicate in the correct way. In fact, this debt collector kept sending text messages to our client, and we had said in the letter that was not a convenient way and asked not to. So that's a violation. In addition, we checked this client's annual credit reports after the debt collector received our letter, and that debt collector did not mark the account as disputed. So those are two very technical but ironclad strong violations. The consumer with Swift Law North, we sued, and the outcomes were fantastic. Which can happen and isn't required. In this case, the third-party debt collector, which was just hired to collect a debt, convinced its client to forgive the debt, which is, a bonus cherry on the top. Because again, the collector didn't own the debt, but was still able to lean in on its client. So that was great. About $4,000 worth of debt that may have been owed that is gone. The debt collector deleted its collections account, so that account, it's like it never existed. Those collections are incredibly harmful to credit scores, to credit reports, to credit worthiness. So two technical violations led to a debt almost completely erased, like it never existed. On top of all of that, the consumer received $1,000 in statutory damage, so got that forgiveness of $4,000, got the trade line deleted, and got $1,000 in his or her pocket. The attorney's fees get paid. In this case, it was about $4,500, after some time in federal litigation to get it settled. And then we pay our affiliate partner for acting as our contract paralegal for its work. And in that case, the affiliate partner got paid about $450, which isn't nothing, on top of helping this client. So the lesson is no case is too small. Even technical violations, these bronze cases, under the FDCPA can lead to such incredible results for the consumer, attorneys, and our partners. All right. And again, these extra credit videos are a little bit longer than our standard videos, so you're paying extra for it. We want to make sure you get some extra value. So again, we're at about 8 minutes of what usually are about 10 to 12 minute videos, but these extra credit lectures will go long. We're on to our case study number 2. This is a repeated violations case, and we kind of consider this one a silver in the middle value. This is a case where a consumer had previously settled a debt with Discover years and years ago, something like 20 years ago. And then about 9 years ago, even after the consumer settled a decade earlier, Discover sued. Well, that didn't go well for Discover. They lost that case, of course, because the consumer was able to prove that he or she had already settled that debt. Well, guess what? After losing that case, it happens again 7 years later. Discover at this point hired a new debt collector. This debt collector was told, "What are you guys doing? You've already sued me on this. I've already proven in a court of law that I don't owe this debt." Discover didn't care. The debt collector didn't care. So what happened? The debt collector nonetheless kept calling and credit reporting as collections. And then Discover sued again with the same lawyers, the same third-party debt collection lawyers. So just a repeated violation case, incredibly stupid. Companies that are too big to fail, they're stubborn, they push forward even in the face of good evidence. So these outcomes were incredible. The client won both defensive cases, never had to pay anything for those. Counterclaimed. And in this case, client walked away with over $50,000 in damages. And that's a lot of money. This client went through a lot, had already years and years ago done the right thing, settled the debt. And on top of that, had to be sued twice, get served paperwork, the embarrassment of having to go to court. Who knows who knew about it? It's in the public record. And this happened twice, 2 separate times. And Discover and its third-party debt collectors, who have the liability here under the FDCPA, didn't care. They just kept pushing forward, kept debt collecting, and really ultimately paid the price. The lessons here is just these parties are sometimes just dumb and stubborn. In this case, the writing was on the wall. It was so clear with evidence provided that this consumer didn't owe this debt. But the other side, they thought maybe we or the consumer were fabricating documents or forging documents just to get out of a debt that was settled a long time ago. It's just such hubris and lack of awareness, and really maybe being overworked, too many files, too little pay, and it leads to some really good cases. So here, a great case example to talk about, really impactful, decision. Not only that Discover, I'm sure now, is thinking twice or 3 times when it's suing consumers, but this person has been fairly compensated, and I hope he or she feels that way. Despite being sued twice on a debt that he or she didn't owe, to walk away with $50,000 in your pocket and not having had to pay your attorneys, that's a big deal. All right, we're going to talk about the last case study, number 3, some real serious violations. This is a gold case. The facts are that a consumer rented an apartment from a large management company in a not too desirable apartment complex, and didn't have a lot of money, and it was one of the only places he or she could rent, so didn't have many other choices. Lo and behold, some of the reviews were true. The management company didn't take care of the place, and our client had a lot of mold issues because there was an AC that kept leaking. Client got doctor's notes, had proven it, lab tested, definite mold, and certain statutory requirements, which you can learn more about later in our landlord-tenant video series, allows consumers to get out of leases in certain circumstances, especially if the consumer follows the requirements. And that's what our client did. Followed the requirements. Again, look at those landlord-tenant videos to learn more about that. And then he or she moved out. Therefore, the law says because he or she moved out, gave the correct notice, was able to prove the reasons why because of a mold, they owed $0. Well, guess what happened? The landlord didn't, remark or take that debt down to $0. In fact, maybe in a retaliatory sense, said, screw it. We're going to now try to get the rest of this lease payment. And that was over $20,000. So this consumer went from, having very little money, having to rent an apartment that he or she may not have really wanted to, but had no choice. Moves in, gets sick, has mold issues. They don't fix it repeatedly, has to move out, is scrambling to find a new place. And now her life just gets ruined. Again, notwithstanding the law saying that she or he owed $0, third-party debt collector credit reports and is very aggressive in debt collecting this illegitimate debt for the full lease amount. Again, the consumer owed $0, but the third-party debt collector, the management company, were saying $20,000. They were credit reporting, and little did we know, ruining her tenant screening reports, which are specialty credit reports that have to do with renting. So at the end of the day, some really awful things happened to this client. The debt collector was so aggressive in calling his or her work that he or she lost a job and was in a really bad place. And on top of it, because this illegitimate debt of $20,000 was being credit reported, and they were reporting some bad information on tenant screening reports, he or she was unable to get a new apartment. Went from having a job, wanting the place to live, to now having no job, ends up effectively on the street. He or she ends up renting a room from a real sleazy way online and gets sexually assaulted. Think about that. That's the gravity of some of these cases. And it all started because some greedy debt collectors and the management company didn't do the right thing. First of all, they should have just fixed the problem, fixed the mold. But then when they refuse to, because landlords think they have all the power and management companies think they have all the power, they just flouted the rules. They didn't care that our client gave the requisite notice. Again, look at landlord-tenant videos later, to move out and not owe anything. Just plowed straight ahead. This poor woman or man said that, repeatedly, aggressively debt collecting $20,000, reporting that against his or her credit, calling someone's work so much that they get fired. And then on top of it, can't get a new apartment because you're falsely credit reporting, you're falsely collecting this amount, ends up renting from a really seedy place online and gets assaulted. That outcome is incredible, but may not ever be enough, in terms of what actually happened here. But at the end of the day, the outcomes were the best we could do and really were life-changing. The debt, quote, debt was gone. Our client certainly didn't owe $20,000. It was acknowledged in writing, would never be collected again. Trade line was deleted, acknowledged in a settlement agreement that the debt would never be credit reported again. And then, at the end of the day, the consumer was awarded and settled for many, many hundreds of thousands of dollars. Whether or not he or she will ever feel fully compensated, I highly doubt it, given what he or she endured. But it's still a lot of power and leverage in these statutes to hold companies accountable. So the lesson here is this can change lives. This young man or woman was distraught, thought, what lawyer is going to going to represent me? If I owe $20,000 or allegedly owe $20,000, what's it going to cost me to prove that I'm right? He or she contemplated filing a bankruptcy just to be done, but instead found, an affiliate partner, found us, found lawyers who were willing to fight, willing to use these, leveraged debt collection, consumer protection statutes to, fully benefit our clients. And that can be debt forgiveness, trade line deletion, material damages, which leads to, a lot of fees to be paid to our affiliate partners. So again, that's a gold, silver, bronze case example under FDCPA.